I appreciate you coming to join me, Matt. We got a couple things I wanted to discuss today. One of those things is a social media post that I saw regarding a Polk County DUI trial. When was that? A couple months ago?
I
You
think,
can
yeah, a couple months ago now.
this Facebook post right here. It was a DUI trial and there was a breath test result, right?
There was, I think it was around twice the legal limit of 1.6 or somewhere around there.
All right. So you took a DUI with a breath test of 0.16 to trial. I know that there was a lot of defense attorneys at the time that were saying like balls of steel, but I think we jumped into it a little bit too far. If you backtrack a little bit and give us maybe a 10,000 foot overview and then maybe dive into some of the legal issues you had, I'll toss that over to you.
Yes, this case involved at the time a Polk County deputy that was off duty and allegedly drinking with some of his cop buddies at a bar. They were getting ready to leave. He sees one of his coworkers leaving the bar. She does some burnouts or something in the parking lot to draw law enforcement's attention. He shows up on scene to try to see if there's anything he can do to prevent her from getting arrested. And in that process, he ended up himself arrested for DUI. It was kind of a crazy scenario. He was trying to help out a friend, but for that, he would have ended up scot-free, but he ended up being arrested for a DUI.
So do they all know each other? Hey, what's going on? Come here, Jason, and let me do these tests on you, or do they not know each other?
So from the videos, it appeared that the deputies that ended up arresting my client knew the female who was pulled over. There were some conversations that appeared that they weren't super close, but they knew that she was a deputy. And when my guy shows up on scene, he identified himself as a deputy, but it was pretty clear that they didn't recognize him.
So you get hired, you know he's a police officer, you know lots on the line, and you know he's probably going to be going to trial on this, not going to take any deals, and it's Polk County, so you're probably not going to get deals anyways. Did you kind of know all the way along that you had this strategy going through? I know we talked about not filing motions. That was one of your strategies in this.
Like we've talked about before, we are kind of the instruments of our clients. Our clients are the captains of their own ship. Some clients say, hey, I just want the best deal I can get. And some clients are like, screw this, I'm willing to go as
Burn the
far
boats.
as, yeah, as far as, I'll crash this ship into the dock if we have to. That was the expectation of my client from the get-go. He was pretty upset, about how he was treated. And he was kind of gung-ho, like, I don't care how far we have to take this. I'm willing to go with it. And even being upfront with him, dealing with Polk County, he kind of understood the ramifications. If he was found guilty, he was likely going to go to jail for a non-insignificant part of time. I mean, typically in other counties, you may do a weekend, you may do 10 days, not that that's insignificant, but in Polk County, I told him, it's probably 30 at the floor. And it wouldn't have shocked me if he was maxed out, just because a judge could say, hey, you're a cop, you should have known better. I'm going to make an example out of you. Whether or not he was prepared or not, he at least informed me that he was prepared to do, whatever. And I had that conversation with him. So, it's more his, for lack of a better term, balls of steel, willing to push that envelope. But
Yeah.
also, there's probably a lot of attorneys out there where even if the client says, I want to go, I want to go, I want to go, that the attorney, we kind of had to match our energies that, hey, if you're willing to go, I'm willing to go. We're in this together. I think if a lot of attorneys would have bailed or tried to pressure him into taking a deal or saying, hey, you need to hire someone
With a
else.
0.16 breath in Polk County, I'm sure I would have been on that list of attorneys trying to pressure the deal, because that seems crazy, taking a 2 times the legal limit case to trial. Can you talk for a minute as to why this got rolled out into 2 days and the challenge you had there, and maybe got home teamed a little bit? I'm not sure. I'll
Yeah,
let you do
so
that.
there's a defense strategy that goes along with it. I've had some breath cases where it's been 2 or 3 days because I'll spend on cross-examination, a day and a half cross-examining either the breath test operator or the agency inspector. And that was a potential strategy here, but given on how the trial was going, it didn't seem to me that between the prosecutor and the witnesses that they were on the same page. It became clear that they may not have been able to get that breath test result into evidence. So towards the end of the first day, when that became clear to me that might be an angle, I kind of shifted gears from my normal strategy to potentially drag this out as far as we could go to, hey, if they can't get that number into evidence, then I want to
Okay.
shut this down and I want to end it right now. And, the prosecutor tried to get it into evidence with, the witnesses that they called, and they tried for probably about an hour to get it in evidence. And the judge,
Hold on, let me set the stage. So you have a jury in the courtroom, or 7 jurors in the courtroom, and you have an officer on the stand, and the prosecutor trying to get this one piece of paper entered into evidence, and he just can't do it. He keeps asking questions and rejected and objection and sustained. And is that what it was? That hour of just brutal slogging it out and objections?
correct. That, the legal term is a predicate. You have to ask certain questions and submit certain documents in a particular order in order to satisfy the Florida evidence code, in order to get that document in. You have to ask questions 1, 2, 3, 4, or you can get that document in evidence. And the prosecutor was just asking question 4 and trying to get it in evidence without asking questions 1, 2, and 3 beforehand. And so they kept asking question 4, hey, I want to get this in evidence. And I would object, lack of predicate. You didn't ask those 1, 2, and 3.
Yeah.
And they'd try to ask question 4 a different way, try to get in evidence, same objection. And they're just sitting there in front of the jury, trying to, hand this document to a witness. And every time they had to keep pulling the document back, we had to go back in the judge's chamber several times. You could tell that the prosecutor was getting frustrated. The judge was getting frustrated. I'm sure the jurors were getting frustrated at that point, but they just simply couldn't do it.
That plays out well in the standpoint of like, okay, well, there's this document that has evidence on it, no matter whether it's a criminal DUI, whatever the case is. And we know this document has some type of favorable evidence on it, but the other attorney keeps objecting. Do you fear that the jury punishes you in a way for not letting that evidence get before them? Do you feel like that's a concern you have to wrestle with?
Yeah, that's a concern that you have to wrestle with, but
I guess
there's nothing. Yeah, there's nothing. There's nothing that you can do on the alternative, because there should have been no reason why that number shouldn't have came into evidence. The prosecutor didn't mention an opening, but my philosophy is to embrace. The prosecutor always likes to say the totality of the evidence, and they only bring out favorable evidence. So I like to have kind of my theme of, the prosecutor's not on your side. They're only giving you what they want to give you. The defense, we've given you everything, the good, the bad, and the ugly. So I embrace the ugly. And I did that in opening and said, hey, you're going to hear that my client blew a 0.16. And listen to that number, listen to how the machine was calibrated and maintained, and watch the video, and my client doesn't look. And so I embraced it all. So I'm the only one that let the jury know what that result was. And if that number doesn't come into evidence, the jury is not going to ignore the fact that my client blew twice the legal limit, because, hey, his own lawyer told him that he blew twice the legal limit. It's always a slippery slope, but we fall back on, hey, you're going to get instructed that what the lawyers say is not evidence. You can only use the evidence that was presented, and that evidence wasn't presented. That's the only fallback that you can go to. And then it's up to those 6 jurors whether or not they can follow the law, because if you follow the law, then you should ignore it. But, human nature is, hey, someone's trying to pull a fast one on me. In my opinion.
Human nature, man. We are dealing with that more and more. We've talked about how the Trump trial may change that back, but I don't want to go down that road. So you're going back into chambers, you're going back out of the courtroom with the judge and with the prosecution. Was the judge was a neutral judge, or do you think he was kind of showing some favor to the state, getting it in there, or helping them get it in?
The first time we went back, I think he may have, in my opinion, given a little more of a heads up to the prosecutor as far as what was missing. Because, we go back in chambers, I was like, Judge, they haven't laid that predicate in order to get that documented evidence. And then the prosecutor's like, well, what do I have to do? And I was like, it's not my job to tell you how to do your job. And it's not the judge's job to tell you how to do your job. So you're kind of SOL at this point, because I'm not helping you out. The judge, who's supposed to be impartial and shouldn't be helping you out, but the judge said, well, according to Florida statute 316-193 subsection 5, this is what you have to do. And, I objected back there and was like, Judge, you're kind of laying it out for them. And his response was, I'm reading what the law is. And so he kind of, in my opinion, it should have been enough to give them a heads up. So
but they didn't pick up on it.
Yeah, we go back in the courtroom, try it again. They still couldn't get it. We go back in chambers. And once again, they're like, well, what do I have to do? You said this. And then I was like, Judge, you already, in my opinion, helped him out more than enough. I'm going to, really object. I'm going to ask for a mistrial if the court steps in anymore. And then at that point, he kind of agreed with me and said, yeah, I've said that I'm willing to say at this point, it's up to you to figure it out.
I had a similar circumstance recently. I was doing a trial on one of those handicap cases, and I filed a motion in limine for corpus before trial. And the judge, who, very favorable to this judge, I like this judge a lot, but he was using the opportunity as a teaching point in order to train a young prosecutor, but they were dangerously close to satisfying the burden. And so I was like, I objected. I was like, Judge, although I can certainly appreciate that you're in a teaching role here, you're trying to bring up a young prosecutor. I get that, but I've been paid and retained to get best results, and I don't give a shit about your teaching job, your teaching role. Like, what you're doing is improper for my client.
And I think, and I don't think they kind of realize or understand that. And I would have, I guess, less of a problem with, you hear the motion and then you grant the motion and say, hey, it is what it is. And then after all said and done, hey, state,
here's what you should have done.
What do you think you could have done better? Hey, here's what I think, and use the teaching moment after the fact where it may detriment, future clients, but it's not, at issue with your case. I think that's probably the proper way to do it, but I, like you, have not seen that in action.
I guess what you're telling me there is that in the midst of trial, where everything should have gone, with the flow, the breath test results should have come in. You actually prepared for the breath results to come in and showed your dirty laundry to the jury right from the start, in anticipation it would. And then the opportunity presented itself where the state couldn't overcome an obstacle. That's where you and I make our money, man. There's no doubt about it that if there's a route for success in criminal defense work and DUI, that right there is where we do it for sure.
Right. And that's what, it was around, I think it was around 3:30, 3:45, the first day of trial. The judge's like, well, how many more witnesses do we have? The prosecutor was like, I just got one more witness and, maybe 15 minutes. And the judge is like, well, maybe we call it quits for the day. And I was like, Judge, if they just have one witness left, 15 minutes, and I knew for a fact the witness they were going to call, there was no way that breath result was coming in through that witness. So I was like, Judge, let's finish up. The judge is like, well, I don't know how long your cross-examination is going to be. I was like, Judge, I will put on the record, I will not ask one question. I was like, so 15 minutes, the state can rest at 4:00. We can go straight into closings, or we can come back tomorrow for closings. I'm not going to put on any evidence. I'm not going to ask any questions. We can be done with this trial in 15 minutes. And it was like, well, the jury's been here all day.
So he knew? So the judge just knew, like, I got to give them, is that what your feel is? The judge wanted to give them overnight to make a phone call?
Yeah, he wanted to give them overnight to figure it out on how to get that, into evidence. I did everything that I could. Typically judges will go to 5:00 to, finish a trial. We finished an hour early, even though the trial would have been done that day, and no witnesses would have had to come back. No, nothing. But, he called it a day at 4. They came back the next day. They figured it out to an extent, but that next day there was an issue with them not disclosing favorable documents to me that it ended up being kicked out, but it was for
different reasons.
Or for different reasons.
I thought I was there on day 1. And I guess I was there on day 2 because I remember those arguments being made. How did that go down?
So the agency inspector testified. So all the documents that they gave me purported to be in compliance with the rules. And there was one document, when they do an inspection, they're supposed to test for mouth alcohol. So they take an alcohol solution, swish it in their mouth, and then blow into it. And it's supposed to read a slope not level or slope not met. So they had an inspection that said that it passed the inspection, even though there was some confusion in that document. So I questioned him on that document, and he referenced another inspection that no one had. So I was like, what inspection are you talking about? Because I only have these 2. And he said, well, there's a third one out there. At that point, kind of content with this, hey, jury, there's this document out here that the state didn't produce, that, whatever. And I was prepared to go forward with that argument if I had to. So I sit down down. And then 5 minutes later, someone comes into the courtroom, hands the state a document, and then they hand it to me. And this document shows that the machine failed the inspection, that it didn't pass. So then I jump up and down. I'm like, Judge, why in the middle of trial is the state now handing me this document that says that, it was not in compliance? And the state was like, well, we knew about it, and we just, they pretty much said we just didn't hand it over. And, the defense is entitled to any exculpatory evidence. And certainly an inspection saying that the machine wasn't working is exculpatory evidence. And since they didn't hand it over to me until in the middle of trial, the judge ended up excluding the breath test result on those grounds.
Yeah, and I think that was a little bit even more narrow than that, because the judge said, look, the state gave you access to the website, so that's good enough. But they also gave you these 3 individual pieces of paper that showed it was good. The fact they didn't give you that extra 4th piece of paper shows like it's a little bit shady.
Right. So I think, according to the judge, if they wouldn't have given me, and I respectfully would disagree with this, if they didn't give me anything, I was supposed to be, have knowledge of hundreds of thousands of documents on this website. But because they gave me something, then they had to give me everything. Is kind of what the ruling was. So, they couldn't get the document in it. They could get the breath test and evidence. They rested. And then we kind of went into closings from there. As we've talked about previously, there's 2 ways for the state to prove DUI. Someone's normal faculties being impaired, or they blow over a .08. So, the judge granted a judgment of acquittal or a JOA on the above a .08 because they didn't prove that, because they didn't get the breath test result and evidence. So the state could only go forward on whether or not my client's normal faculties were impaired based on his field sobriety exercises. So they made the argument that, hey, look at the video. He was obviously impaired. And I said, look at the video. Obviously, he wasn't impaired. And the jury, thankfully sided with me on that one.
Yeah, I've watched that video and prepping for just roundtable trial with you, and then also preparing for this. From my understanding, you got permission to share this, right? So we're good here. Correct. I got it blocked out anyways.
Yep.
I just got a segment of the walk and turn here. He doesn't look all that good when he's going to go down the line. I think he goes down like right now. It doesn't look bad here, right here in particular, but you can tell he's not necessarily hitting all his heel of his toe. He raises his arms up when he turns around and kind of stumbles on the line a little bit. And there's just a little bit of stuff. Actually, it doesn't look bad.
Right.
So it's one of these like mediocre, like it could go either.
Right. So the one leg stand and the walk and turn were, in my opinion, slightly above average. I think he put his foot down maybe once around, I think it was like 12 seconds or no. And so they weren't great, but they weren't terrible. But then on the finger to nose, and then especially on the Romberg balance, where you estimate 30 seconds, he was right on 30 seconds. So he knocked that one out of the park. The argument was he does 4 exercises. He literally scores perfect. Like there was literally nothing better you can do on the Romberg balance. So let's just say that he fails 3 out of 4. That's 75%. Is that proof beyond a reasonable doubt? And I was arguing that that's not proof beyond a reasonable doubt, especially when you take into all considerations of, nerves and balance issues and all this stuff. Him estimating 30 seconds perfectly. The cops will testify that, alcohol is a CNS depressant, that it slows your time. So you would suspect it to be, 35, 40, longer. And his internal clock was right on the money. So, if he's perfect on any of them, then it can't be proof beyond a reasonable doubt that he's impaired.
That's really good. It's really hard to overcome those breath results, though. So I wonder how this goes if if those breath results come in. So that's an interesting take. That's a much bigger hurdle. You have got to overcome both in that scenario, both the breath test results and their observation.
It is. But typically it's, you set it up in jury selection. When people talk about impairment, some is, unsteady on their feet, someone smells like alcohol. And then when you say, what is someone that's twice the legal limit? In the people's minds, they're like, he's falling down, he's throwing up on himself, he's doing this, that, or the other. And then you show that video and you say, hey, you're being told you can use your common sense. And your common sense told you when someone's twice the legal limit, they're going to be throwing up, they're going to be stumbling, they're going to be passed out sleeping. Look at that video. My client's none of those things. So how accurate is that? And that's the argument that you have to make in that, in that scenario.
One of the things we talked about on, in prior conversations on this channel, and then just in general is, what can people do to help themselves out when they're pulled over by the police? And we kind of evaluate, we have these best case scenarios, like keep your window up and wouldn't say a word, wait till you yank me out of the car. We always look for people that have insider knowledge and how they handle the scenario. We have an officer here who's being arrested by his own department. Do you think that he did himself any favors? How did he handle that interaction? What harm did he cause you? Do you think you could have phrased this a different way to get out of being arrested? I'll present all of those to you and just open that up to your thought.
You and I have both handled numerous cases involving law enforcement and DUIs. I mean, I'm sure there may have been some, but I can't recall a law enforcement DUI case in the past where they've done anything. I mean, typically, whether it's law enforcement or whatever, the less evidence you can give them, typically the better for your case. So if you refuse field sobriety exercises, refuse the breath test, there's arguments that can be made against you, but I think there's just as many arguments for you that we can make, on your behalf. The less evidence that the state has against you, I think the better it is for your case. One of the things that I don't even know if I mentioned to you, the biggest hurdle, and I mean, this may be kind of the biggest, win. I never really thought about it this way, but the arresting officer on this case, they called in someone else to do the DUI investigation. And the arresting officer used to be partners with my guy. So she took the stand and said, hey, I know Jeff Lauder. I worked with Jeff Lauder for a year. I know how Jeff Lauder talks. I know how he walks. I know how he does everything. And Jeff Lauder was not the Jeff Lauder I knew the night I arrested him. He was impaired. And
that's crazy. So the lady doing the field sobriety exercises, the dude?
Yeah,
that's what we talked about at the very onset.
Yeah, worked with him, side by side for months, if not a year.
That is wild. I'm using that transcription software that transcribes all my body camera videos now. And in the transcripts of this one, it says something like, are you comfortable in those shoes? He's like, yeah, babe, I got me some Air Maxes. She's like, oh, that's bougie. I was like, this seems like an inappropriate conversation for what we're doing here. So you remember that? Or did you hear that come through?
Yeah.
Let's compare and contrast that to this other scenario we have with an officer. We saw this name come across our desk the other day. We both know this guy that got arrested. And back in the day, I mean, he was a cop when I was, back in the day when I was a cop doing DUIs. He certainly knows what he's doing in the realm of DUI. He was never a top performer in the DUI. Well, no. He was top performer for DUI compared to most cops, but within our unit, he was just average, but certainly knows what he's doing from a DUI standpoint. And, I confirmed this is him. So this is kind of the countering position to what your guy did. He's involved in an accident. And the officer says, I observed such behavior, which is a lack of balance, bloodshot eyes. When I asked for his name, I could smell the distinct odor of alcohol fumes emitting from his breath. He was also unsure about the location of his wallet or phone, asked multiple times. He understood that I was conducting an investigation regarding his ability to operate a motor vehicle, to which he immediately stated, I refuse everything. I attempted to read the instructions regarding the standardized field sobriety test, and blank again stated that he was refusing to submit to any testing. I'm super excited to see that video out, to see how that goes through. That's what I would expect out of most cops. And so the fact that your guy down in Polk County didn't do that.
My guy, he wasn't a deputy very long. I think, less than 3 years. And I think, he maybe had done one or two DUI arrests in his career, but still, like, I would think that that's kind of locker room water cooler talk in the academy, or, when you're doing FTO training and, things like that just kind of come up. So yeah, I mean, it's certainly in the realms of cop DUIs. It's certainly, the exception rather than the rule.